The Singapore Convention on Mediation. There are four alternatives for the management of conflicts: negotiation, mediation, arbitration, litigation. After the Second World War, arbitration played the leading role in out-of-court international commercial solutions, thanks to its flexibility, confidentiality, neutrality, the preference by lawyers, and its enforceability. International arbitration is based on the UNCITRAL model law on international commercial arbitration, approved in 1958, the New York Convention, with 10 signatory countries. Nevertheless, international commercial mediation has been gaining momentum because it is confidential, very flexible, quick and cheap. However, until August 7, 2019, the enforceability of the agreements was not guaranteed unless the parties had to go through a slightly articulated proceeding. Among others, arbitration, mediation, arbitration. In 2014, the United Nations Commission considered a proposal by the United States to undertake a preparatory work for a convention on the enforceability of international commercial mediation agreements. The goal was reached in only 4 years. On December 20, 2018, the United Nations General Assembly adopted the Resolution 73/199, named Model Law on International Commercial Mediation, including consistent standards on the cross-border enforcement of international settlement agreements resulting from mediation. The convention was signed in Singapore on August 7, 2019, and was named Singapore Convention on Mediation. 46 countries signed it, including the United States, China, India, South Korea, and Saudi Arabia. Russia, Japan, and the European Union did not sign it. 46 signatory countries mean a high degree of support to the Singapore Convention, compared to the only 10 signatory countries of the New York Convention on International Arbitration of 1958. Few months later, the number of signatory countries reached 52, and above all, Singapore, Fiji, and Qatar ratified the convention. According to Article 14, this convention shall enter into force 6 months after deposit of third instrument of ratification, acceptance, approval, or accession. Therefore, the Singapore Convention on Mediation entered into force on September 12, 2020. Thanks to its enforceability, international commercial mediation now has teeth. Singapore Convention on Mediation. Contents. The Singapore Convention on Mediation and the Model Law on International Commercial Mediation 2018 together provide an international regulatory framework which is a good reference for states interested in giving more efficiency to the solution of international trade disputes. A quick insight at the main principles in the Singapore Convention on Mediation. 1. International commercial mediation. Mediation is a process whereby parties attempt to reach an amicable settlement of their disputes with the assistance of a third person or persons, the mediator, lacking the authority to impose a solution upon the parties to the dispute. Commercial disputes are disputes related to commercial trade and financial operations. They are excluded disputes where one of the parties is a consumer or an employee. They may have unequal bargaining power, or disputes related to personal, family or inheritance matters. They may be also excluded agreements already approved by a court or otherwise enforceable as court judgments or arbitral awards, in order to avoid overlapping with the New York Convention on Arbitration, 1958, and the Hague Convention on Choice of Court Judgments, 2005. International. At least two parties to the settlement agreement have their places of business in different states, or the state in which the parties of the settlement agreement have their places of business is different from either the state in which a substantial part of the obligations under the settlement agreement is performed, or the state with which the subject matter of the settlement agreement is most closely connected. 2. Agreement. The agreement may be recorded in any form in writing, electronic form included, signed by the parties and the mediator, with a certificate from the institution that administers the proceeding. There will be a lot of room for the online dispute resolution, as long as there will be protocols for signature authentication shared at an international level. The blockchain will be useful. 3rd, enforcement. Each party of the Convention shall enforce a settlement agreement in accordance with its rules of procedure and under the conditions laid down in the Convention. 4. Refusal to enforce the agreement if it is proved that a party was under some incapacity, or the agreement is contrary to the law that should govern it, or the mediator did not comply with the standards of the proceeding, or the agreement has already been approved by a court. The Singapore Convention on Mediation, into force from September 12, 2020, and the Model Law on International Commercial Mediation provide a regulatory framework. The Convention received strong support from many countries. Nevertheless, there are also concerns and criticisms. Understandably, given the complexity of the subject and its likely application throughout the world. The Singapore Convention on Mediation. Challenges and opportunities. The Singapore Convention on Mediation, into force from September 12, 2020, received strong support from many countries. Nevertheless, there is no lack of concerns. According to many practitioners, enforcement should not be necessary because the parties usually comply with the settlement once it's reached. Among the principles of the Convention, agreement must be recorded in writing, signed by the parties and the mediator. However, because of the confidentiality of the mediation proceeding, many mediators may refuse to sign a settlement agreement. An agreement could be enforceable if the party provides proof that there was a serious breach by the mediator of standards applicable to the mediation. But what standards are applicable to those proceedings? According to Harris-Sippel, as a result of the Singapore Convention, mediation will change to the worse. Mediations will last longer, will become more costly, and success rates will drop substantially. In other words, the lawyerization of mediation. In my opinion, the main concerns in the application of the Singapore Convention are the following. Enforceability could change the real nature of mediation, making it adversarial. Most professionals will shift from arbitration to mediation, but will continue using the same techniques. It will not be easy at all to realize a common standard of conduct for mediators and mediation, given the huge differences in cultures and in ADR techniques in different countries and continents. Moreover, mediation is not always the best way to resolve disputes. If the parties live in countries where there are enforcement difficulties, a local court decision could be the best choice. If it is necessary to interpret standard rules, which will be included in future contracts, an arbitration award would be the second best. If time is money, mediation could be the only way to go. Enforceability of commercial mediation agreements may be a chimera, as well as for arbitration awards. Enforceability must be recognized by a court. The judgment must be executed by the local authority, and recoverable assets are needed. All three conditions not always occur. Mediation proceedings should take account of different cultures and practices. Hybrid clauses are used in many countries, mainly to save time and money or to enforce the mediation agreement through an arbitration award. And, worst of all, mediator and arbitrator are the same professionals in many proceedings. Mixed mode dispute resolution, interplay among mediation, evaluation, and arbitration have to be analyzed. In a nutshell, what kind of mediation will we have in the future? The Singapore Convention on Mediation, into force from September 12, 2020, is a very important step for international trade. More precisely, is the first critical step of a long way to go.